There's a procedure available called a complaint for determination of parental rights, which doesn't have the rest of a divorce attached to it, where there's issues of spousal support or property division. The court is not authorized to do that if the parties aren't married, but they can make determinations as to what is in the children's best interests and issue orders that determine where the child lives, what contact is ordered for both parents, separately, child support, whether rights, for example, to make educational, mental health, medical decisions are allocated to one party or the other. Maine, in both the context of a divorce and parental rights cases, uses its own language, which was designed, I think, to take some of the harsher aspects of traditional language of custody, visitation away, and Maine has actually adopted the idea as well that unless there's quite a good reason to do otherwise, that parents of children should share parental rights and they make decisions as best they can together, and they should consult with each other and consider each other's opinions and try and reach an agreement. Sometimes that's not always possible, but they should try. And then the court can determine where the child will live most of the time. That's considered primary residence. And then contact is what the other parent has, and it's usually specific, and the parties are free to agree to any other arrangement that they want, but the order is intended to be specific so that at least it can be enforced if there's a disagreement. Maine is a child support guideline state, which has had a beneficial effect of taking much of the fight about child support out of a case. Maine has adopted and recently revised the guidelines, which are essentially a chart that determines what the child support would be for the number of children that the parties have, based upon their income. Now, if one parent has primary residence where the child lives more than half the time, the other parent, except in pretty extreme circumstances, would owe that parent a duty of child support to provide for, a roof over the child's head, food, clothing, and minimum basic requirements. Maine has also seen an explosion of substantially equal care, which is a wonderful idea that has just grown exponentially, which is where both parents have equal time or very close to equal time with the child. They equally participate in the raising of the child. And in those circumstances, when each of the parents has essentially equal time with the child, the courts have seen the tremendous benefit of the child. The parents actually like it if they can accomplish that, because they essentially have a separate life as an adult, and they know that when they're engaged in that, their child is with someone who loves them and protects them. And then at the other, when the child switches over, you're a parent who is essentially making day-to-day decisions for that child while that child is in your care half the time. It's turned out to be a sort of a lovely idea that happens quite a bit. The child support guidelines are calculated a little bit differently then, and then the higher income parent would owe a portion of what would be traditional support to the other parent, and they split the costs of health insurance, child care, and medical expenses, for example.